Yeah, come on, John. Yeah. This is Coke Zero, by the way. I just want everybody to know that I'm not having a highball this early in the day. Well, anybody that knows me would question that. But I'm not like one of our other friends in the cyber world who does give his presentation with a cigar in one hand and a martini in the other. I haven't gotten there yet, but I'm going to. So this part of the program is where we're going to ask you to engage here in just a second, but we have assembled a panel of experts here to talk about this concept that data breaches suck. You know, there's been no shortage of information by academia. We've done research on it that the actual notices themselves don't do anything for consumers. They don't prompt them to take action by and large. And when they do take action, it's not particularly helpful. So, you know, the whole concept of how we notify people of a data breach or a data exposure, we need to rethink it. We need to improve it at a minimum. We probably need to rethink it from its entirety. So we have assembled this august panel of experts to talk about this very issue. So despite the fact that it says Kim Sutherland, Kim, this is like Broadway, the role of Kim Sutherland today is being played by James Rotolo. James of Grant Thornton fame, not of LexisNexis, John Braote from National Consumers League, and Paul Bond from that little law firm, Brand X, right, as we sit here in Venable. Gentlemen, thank you for being here. Okay, the first question. We'll start with you, Paul, because you actually practice law in this area, and you have some experience with paying clients.
Yep.
Do data breaches notices actually suck?
Data breach notices absolutely suck. Is this on? For one. Hello?
Oh, there you got it.
All right. Data breach notices absolutely suck. First, because every time you send a data security breach notice, you're telling someone they don't want to hear. Every time you get one, you're learning something you don't want to know. They also suck because they're really in between the two places that really matter. It really matters that we fix the broken identity authentication system we have in this country. That's a bigger fix than will come about because any given company sends a letter to any given person. It's also really important that we have almost no fault systems for people to be able to remediate identity theft losses they may have suffered. Again, not something you're going to get from a data breach letter. The data breach letter starts out from the concept of almost zero baseline of background risk of identity theft. The idea that, well, your identity is some pure untrammeled snow, and it's only because of this particular incident that now suddenly you're at risk of identity theft. Whereas really, as we all know, the risks to identity theft are epidemic and persistent, regardless of whether you get one of these letters. I think the other reason they suck is because so many have gone out and so many do go out that people tune them out. I've gotten more than a dozen over the last few years. I got notice from my bank that someone on New Year's Day, someone stole $630 by making fraudulent purchases in my name. The thing that mattered to me was that there was a remedy in place that I was able to use to essentially write off or charge back those fraudulent charges. The idea of a system that works with a remedy that's not just a letter that says, hey, tag you're it. That would be a real improvement, but I think as you were suggesting, James, that would require us to rethink the way that all of this works.
Thank you, sir. John.
Can we hear me?
There we go.
Great, thank you. Number one, thank you to ITRC and the Better Identity Coalition for inviting us to be part of this panel. Do notices suck? I'm going to take a contrarian view. I don't think they do. do they are they worth what they originally created to be worth? Probably not. In the wake of the Experian breach, states started passing breach notification laws. The idea behind it was that let consumers know what they can do to protect themselves. Back when we did think that our identities were sort of pure, untrammeled snow, that's clearly no longer the case. There's clearly rampant breach notice fatigue among consumers. They don't pay attention to them. But I do think it's important that there be a public record when companies fail to uphold their data security commitments to their customers. And I think breach notices do that. I think the evidence that they don't suck is in the report that James just talked about. How do you come up with that kind of data to find out whether companies are upholding their obligations? How do you help enforcement agencies know when they need to exercise their authority under, say, Section 5 of the FTC Act against companies? I think notices do that. And so I think while they don't have the same worth that maybe they were originally intended to for individual consumers, there is definitely a significant worth still for researchers, for enforcement agencies, and importantly, James, as you mentioned in your presentation earlier, for businesses who may not be the subject of the breach themselves, but if they are working with the same vendors, if they are using the same underlying technology for things like customer relationship management, they can take action to try and head off a breach involving those same vectors with them. So no, I don't think they suck, but they just suck differently now.
And I think there might be a useful distinction between, so when you send out one of these notices, there's actually usually several notices that you send out. You send out the notice to the consumer, then sometimes that's individualized by state. There are even some state requirements, like in Massachusetts, where there's a requirement that you don't explain everything that went on with respect to the breach in the notice to the individual. But in many states, there's also a requirement that you notify the government. And oftentimes the government notification required, depending on the state, requires much more detail about the cause of the breach, as well as the total population of notice recipients and the notice recipients per state. Much of that information, many of those state governments post that to their website. So, when we talk about breach notices, I think the notices to the individual to a certain extent serve a different purpose than the notice to the government. And if we're looking for the more full set of information, it's not always available, but oftentimes it's available on the government report versus the report to the individual.
Good distinction. And then Mr. Ruotolo, who actually deals with anti-fraud all the time.
Yeah, so as sort of the fraud investigator on the panel, first of all, thank you for allowing me to play Kim Sutherland today. I'll try to do the role justice. I am going to split the middle here and say that I think that notices are sort of a necessary evil, and I'm glad they exist. But the implementation of them often sucks for three key reasons. One, no all, but they're written by attorneys. And they're not for normal people, and they're increasingly in 8-point font and just multiple pages. Nobody wants to read that. Two, there's not a lot of useful information typically in those notifications for those of us that are interested in stopping fraud, understanding what the threat vector was and how it was perpetrated, what information was compromised. As we're seeing from the research from the ITRC, increasingly that information is left out of those notifications. And three, sorry, what was my third point? It was a really good one. Sorry. So the third one, the best one, is the fact that it's essentially a prize notification that you have won a year of free credit monitoring. And so, which when you look at sort of the risk scoring that we looked at earlier, with a breach that's a 7 on the risk score that included a lot of health information, the types of protections and things that you should do to protect potential future fraud from happening with your identity, often unrelated to the type of protections that they're giving you. So health fraud, for example, free credit monitoring is not necessarily the best course of action, but that's the default one that everybody provides. And so there's really a disconnect between what's included in those breach notifications and the steps that consumers should actually be taking to protect themselves from threats going forward.
Thank you. Let's move on to the next question. Why is there less information being shared in notices? So to the degree that you gentlemen know or have thoughts or just want to wildly speculate, here's your chance. So we'll go reverse time this time. So Mr. Rotolo.
Yeah, I'll wildly speculate, which is that less is more, right? So, why introduce additional risk to your own organization and, put information out there that can probably only hurt you? And unfortunately, I think many organizations are incentivized less to protect the consumers that are impacted and more to protect their stock price. And so, and unfortunately, those two things are not always aligned. In some cases, they're diametrically opposed. And so I think that's oftentimes what we're seeing is that there's a sort of a critical importance to protect the corporation here, and often at the expense of the consumers. And so one of the things that organizations are doing is pulling back and guarding that information, even if it might be helpful to the consumers that would receive that info.
Yeah, and just to I think build on that, and again, wild speculation here, but the despite FTC warnings that failure to notify in a timely manner, to include sufficient information in notices, I don't think companies really are all that worried about enforcement action against them. By my thoroughly unscientific review, the FTC brought one case last year against a company for failure to uphold its breach notification obligations, and that was against Cathay Press. Against how many breaches last year?
1,802.
1,800. So a fraction of a percent of companies will ever be investigated for their failure to uphold breach notification obligations. Add to that, even if you are part of the unlucky 0.01%, chances are that your fine, if you have one, is going to be a slap on the wrist. The Supreme Court has effectively neutered the FTC's ability to hold companies accountable under its 13B authority. So I just don't think there's much fear out there anymore. So if there's not much fear of the consequences, why should you take the risk, like James just talked about, of reputational or stock price damage? Seems like a pretty good bet to me to take that risk. What does the lawyer think?
Counselor, as the one person who may actually know something here.
Well, no, but I will say two things. One, as you alluded to earlier, James, the data breach notifications are creatures of state law for the most part, and the role of the company is to go down the checklist that's provided by state law. To the extent that that checklist doesn't include give us the number of people or give us the root cause, that's essentially what I think a lot of companies are probably responding to. I would also note, on a less legalistic note, I'm not sure for an individual consumer how much it matters to me in terms of my next steps, doing the next right thing to protect my identity, whether I care that it was a malware attack versus a supply chain attack in the API. I don't know how much I care whether it was 400 other people whose social security numbers were involved or 40,000 other people. From my point of view, is I might care about that as a data protection authority, the FTC or State Attorney General. I may care about that as a business counterparty. But in terms of what I as an individual should do, that information isn't the most important stuff to me. And I think if anything, what should be expanded is a description of the other ways you can protect yourself, in addition to the ubiquitous credit monitoring.
Okay. Get your questions ready. We're getting close. What is the risk, if any, of less information being available to businesses and consumers? We'll start in the middle this time. So, John.
Sure. The risk of not having enough information, I think, is most acute for businesses. Businesses, I think, are best positioned to take action that protects consumers' data at scale. I have been doing consumer education work for 15 years now at NCL, and not a day goes by, it seems, that I don't tell consumers to don't use the same password across multiple accounts. Don't click on suspicious links, and they still do. And I'm just one person, and there are many other people who have been investing in that kind of education for years, and I haven't seen a real noticeable change in consumer behavior on that. What does change things for the better is when companies do things like invest in multi-factor authentication. That's because those are solutions that can be deployed at scale that actually do have an impact. Are they perfect? No. But I do think that they do help consumers take the steps that they can do to protect their own data. But I think it's a fallacy if we are depending on consumers alone, or even putting a tremendous amount of burden on consumers to take the steps they need to protect their information themselves. They're just outgunned by the hackers, and there's just too much data out there about them for them to protect it all. So I think I tend to put a lot more weight on what businesses can do to protect the data that they collect about consumers and that they monetize.
Yeah, I absolutely agree. I I think, again, just a plug for the ITRC. I think one of the most valuable things about the ITRC is that it actually walks consumers, victims through responding to identity theft, because it's essentially comically unfair how complicated the system of identity authentication is in this country. To put any individual, even sophisticated individuals, to work through all the different ways that they have to protect themselves after a data breach. But I think where we have seen progress is with businesses essentially asking increasingly sophisticated questions of their vendors, being asked increasingly sophisticated questions as a service provider, and those standards kind of ratcheting only up, both due to increased government regulation and increased disclosure requirements, potentially coming with the SEC for public companies, and as well as kind of industry best practices.
I do a lot of fraud risk management work and fraud risk assessments for organizations. And for government agencies, the GAO has some pretty good instructions for what's required in a fraud risk assessment for a government agency. In the private sector, the Association of Certified Fraud Examiners has some pretty good guidance that's published about requirements for a fraud risk assessment. One of the things that we look at is who the persona is of the individual that's perpetrating a fraud. The other thing that we look at is what is the vector or the channel, the system that they're using to commit the fraud. And the third component is the scheme itself. How is it perpetrated? And so we gather this information so that we can proactively evaluate the controls that organizations have deployed to protect themselves against those types of threats. So we've amassed after having done this many, many times, we've amassed a database of about 1,000 different schemes that are all mapped to those personas and channels and individual fraud threats. And what's shocking, of course, is that list continues to grow every week. And so the information that we're talking about here is the information that those of us that are in the anti-fraud community need to be able to be more proactive and help organizations and individuals better protect themselves. So this information and understanding how fraud or information theft is perpetrated is really critical for us in being able to protect organizations in the future.
Moving on. One of my pet things, in 2022, there was an average of 7 data breach notices, publicly released data breach notices every business day. In the European Union, under the GDPR, the last year we have data for was the previous year, but there were 356 every business day in the EU. So do we really believe that there are only 7 a day in the US? And is there risk if there are undisclosed breaches?
Yeah, I'd say I think 7 is a huge undercount for some reasons that you suggested in the breach report, which is, for many instances where companies are seeing things that may not quite rise to the level of a breach, but are an exposure or some risk, they're messaging it not in formal, meeting the four-corner definition of a data security breach, but through other security messaging directly to the consumer, whether it's their email, their website, and things that may not be called, data security breach or, evidence of a compromise, but nevertheless get that point across. I also think, as you mentioned, the lack of a central repository, really hinders us in being able to figure out what the accurate picture is.
So I'm not a GDPR expert, but what I'm guessing accounts for that disparity is probably a combination of things, starting with the definition of what a breach is. If your definition of a breach is based on existing state laws or the FTC's interpretation of Section 5 in previous cases, I think it's probably easier to make the call that this thing that happened isn't necessarily a breach. Whereas under GDPR, they have a comprehensive EU-wide privacy and data security law. So the definition of what is a data breach is defined. It's not up to interpretation by individual breached entities. So I think that's probably one reason why you see more breach notices in the EU. You also have, I think, most folks who I work with in the privacy community consider the EU to be a tougher regulator when it comes to privacy and data security than the FTC or state AGs. So, if I was to sort of choose between those two numbers, I would say the EU is probably more accurate, with the caveat that I'm not specifically a GDPR expert to give that number a threat score like you had earlier. So go ahead.
I'm sorry. I was just going to say one other consideration is the lack of the difference between the class action culture in the U.S. versus there's some collective actions in the EU countries, but much less. Essentially, every time a company in the U.S. is sending a data breach letter, they're considering this may be an engraved invitation to bring a class action lawsuit. That creates a different set of incentives that may not apply the same way in the European Economic Area.
Mr. Rotolo?
I'm not excited about getting more breach notifications in my inbox, but they are probably happening. I think we used to say that there's only 2 types of people: people that have had their identity breached and those that will. We're past that point, right? Everybody already has. Everybody in this room, right? Everybody in America, by and large, chances are your information has been part of one of these thousands of breaches that have been occurring over the last few years that have been reported. There are probably several thousand more that have not been reported. And so, that's become sort of the new reality. And so, I start to wonder that there is a level of desensitization around this. And I'm not sure at some point if the only answer and solution that's provided in any of those notifications is more free credit monitoring, let's just give it to everybody and be done with it. And then figure out what's an actual practical solution to helping people address this future risk.
And to your second question, James, about what's the risk of an undisclosed breach, I think the risk that I would most immediately see is the breach to other entities that didn't get breached. As I mentioned a few minutes ago, why I think data breach notifications don't suck. It's because they provide information to other entities that might have a similar risk profile as the breached entity that still have time to take action to mitigate that risk. So when you fail to disclose that breach, I think you are depriving other entities of that opportunity. And I think, you're also, but, at the same time, I'll grant you that there is a risk of disclosing a breach. And many state laws, I think, speak to this, that a state AG or other regulatory entity can step in if there's an active investigation underway where disclosing the breach would hinder that investigation, then you shouldn't disclose it. And I think, again, if you're in that case, the risk of disclosing it is probably greater, that you may, miss an opportunity to nab a bad actor, for example.
I'm going to go off book because you knew it was going to happen eventually. Let's compare Oregon to Arkansas. You don't have to know the subtle differences between the two.
Yeah.
But Oregon is very similar to the GDPR in the sense that it is a joint decision about whether the notice is issued. It's the breached entity and law enforcement. They determine if there is the risk of harm. If there is, then there's a notice issued. If there's not, there is no notice. Same thing with the GDPR. It's a joint decision between the breached entity and the data authority. What's the advantages or disadvantages of an expansion of that thing in the that kind of a process in the U.S.? I know it'd be a pain for law enforcement, but would it result in more accurate and better information?
Yes. I think, I'm familiar with that in a number of states, including like Florida. And depending on the state, it could either be you talk about the risk, either in consultation with law enforcement or with someone like, I think in Florida, it's the Office of the Attorney General. And essentially you present your case as to why, based on these facts, we have no reason to believe there's an imminent risk to the misuse of the data for financial fraud or identity theft. I think that's a really useful conversation to be able to have with the party protecting the public interest, where you can lay the facts out and have that conversation, as opposed to companies making that decision on their own or kind of in a vacuum. I think that's really useful.
Well, I'm curious on that point. Are law enforcement or state AGs equipped with the knowledge to be able to push back on that if they disagree?
Oh, yes.
Okay, all right, all right.
That's been my experience. And more often than not, when you have that conversation, the result is, well, we think you should notify. But it at least allows for an airing of some objective reasons and making an argument. And I think it's a useful part of the deliberative process where it's available.
I'm a supporter. I think having an independent party as part of the evaluation is a good idea. Certainly, if you're the entity that's been breached, you've got a lot going on, a lot of concerns. Some of them are very conflicting, and so having somebody with a more objective position to evaluate that, I think, is good practice.
And you may just not know. So with respect to a particular scheme or a particular compromise, you may say, well, the credential at issue is not that valuable, not that dangerous. But someone with a broader perspective may be able to say, well, actually, it's the skeleton key to this new obscure scheme. So with that additional information, you might want to rethink your risk analysis.
It might be your first breach, but it's certainly not the first one that's happened, right?
Okay, last question, and this is where we're gonna also open this up for everybody else to weigh in as well. What should an effective data breach include, and how should it be delivered? And take that as broad or as narrow as you want.
Who's getting the notice?
That's for you to decide.
Okay.
I'm giving you Twitter level God mode power.
Got it. Got it. So let me put on my Elon Musk hat here. And no, the information provided to consumers is the most effective information is what happened and what are your actionable steps that you need to take. That seems to me to be most useful. I think it was mentioned earlier, the consumer doesn't care whether the breach happened at a supplier or because of malware or or an insecure API. They just need to know that there's a risk and here's the steps to take. Um, and are there other options, right? Beyond dealing with a company? Like, who do you complain to if you notice suspicious activity on your account, for example? That seems to me to be the most useful information for consumers. I do like the idea that entities with greater sophistication, regulators, researchers, class action attorneys, should have additional information. And so having a more detailed breach notice available for those entities and for consumers who are interested, I don't see a whole lot of downside to that. How should it be delivered? I think giving entities that are breached the ability to post it on their website or put it in a local newspaper is horribly limiting. I think that consumers should receive it in the same way. If they provide information that allows the breached entity to deliver them a notification, an email address, for example, that's how it should be delivered. But getting away with just putting it in a newspaper when we all know that local newspapers, for example, have been hollowed out, I think is not a recipe for good consumer information.
Yeah, I agree. I mean, I think it should be delivered the same way that to the extent that there's an ongoing relationship between the data subject and the company sending notice, I think they should communicate it the same way they communicate offers and promotions and everything else that they want people to hear about. They should use those same messaging tools to be able to push out this information. I think an effective breach notice should inform the individual that what personal information concerning them has been impacted, was in the records that were impacted, either directly in the notification or providing an easy lookup tool. I think that's one of the biggest gaps right now, is in many places, you have a very general description of what personal information it was, and people care a lot. Well, did it include X, Y, Z? And that information may not be in every letter, and there may not be an easy way to get it. But otherwise, if it's going to continue to be companies sending letters themselves concerning their own events, I think you're going to continue to see a notice that closely hews to the legal requirements. If we turn it into something that's more of a public function, I think there could be a change in what the notices look like and how they work.
Yeah, I think the most critical information that's currently lacking in notices is the specific details about what information was compromised, the particular risks and threats that a consumer faces, and how that information can be misused in the future, and then what the specific and tailored recommendations are about steps the consumer can take to protect themselves based on those risks. And so today, it seems like the advice is always very generic, right? Your account number was stolen, your name, your email, your social, and you should put a freeze on your credit, and that's always the answer. That's not always the answer, right? There's a whole bunch of other potential steps that can and should be taken depending upon what type of information was stolen. If there was healthcare information, your steps might be different. If your card numbers or your bank account numbers were stolen, there are different steps that you should take than if it was just your social, right? There are certain and particular things that consumers can and should do to protect themselves. None of that information is being communicated in the vast majority of the breach notices that I've seen.
And of course, you can always go to www.idtheftcenter.org, where you can live chat with an expert advisor or call us at 1-800. Okay.
Free of charge.
Now, your turn. On your desks, and I'm sorry if you folks are in the seats in the back, somebody will get you a microphone. There are microphones on your desk, turn them on. If you have questions about, or suggestions in this case, about what should a data breach look like and how it should be distributed, or you have questions about any of the things that we have thrown at you in the fire hose for the last little while, here's your chance. Bree actually does not have a question. She's just going to play microphone carrier.
Yeah, my question's actually really focused on where we're seeing root cause kind of level of notification dropping. And specifically, what I'm curious about is whether we're seeing any correlation from, and I hate to say it, and everyone can shoot me, from a political perspective, right? Because we are finally seeing, in a very good way and in a very exciting way, especially for policy nuts like myself, legislation coming out saying, hey, we need better detailed reporting, better logging, better notification to some extent. And that seems to be now matching up with a sudden drop in that type of data coming out. Is this purely coincidental, or should there be some considerations in the types of policies and where these enforcements are coming from to make sure that we're still getting reliable data and we don't get a pushback? And again, I apologize for that topic.
Oh, no apology necessary. Do you guys want to, you guys want to tackle that one first?
Yeah, I mean, so I can't speculate on the correlation you're drawing between sort of more detailed laws about what needs to be disclosed. But what it does seem to tell me is that in spite of regulations that might require that, companies don't seem to be following the law or is interested in following the law, or potentially even going beyond what the law requires to provide additional information. And assuming my hypothesis is true about that, and I think it is, the question is why? And not to beat a dead horse, but I don't think that there's much fear of the consequences of that. FTC can't bring the same kind of fines it did before. State AGs are overworked. Courts aren't granting standing when you go to court as a private litigant. So what's the downside of not putting more information out there that's going to potentially harm your business? I mean, you tell me, is there a huge downside to running that risk? I mean, Facebook got fined, what was it, $9 billion in 2019, and their stock price went up.
As I said, my experience has been, companies look to what the law currently is and work backwards from that checklist. Generally speaking, when there's a breach, it's a house on fire incident. There aren't sophisticated discussions of the nuances of forthcoming policy. Essentially, the issue is we need to get this letter out. It needs to include the following information. And if the states, in most cases, or like the interagency guidance for the federal agencies, to the extent they're looking for something else, we're relying on them to put it on the list.
The one thing I would add to that is on the policy side, if you look at the draft that cleared the House Committee for the Comprehensive Privacy Law last Congress, now been reintroduced in this Congress, did not preempt the state data breach laws. And the state data breach laws are the problem, but the federal proposed federal law would not have touched them. So for those of you who are interested in that topic, that might be something you want to speak with the members where you have relationships, because that is an easy fix. Maybe it needs to be in a separate bill, but leaving it as it is what is creating the problems we've been discussing this morning. Yes, ma'am.
Panel first, and then this one as well. I was a privacy officer for large companies for quite a while. Another value of breach notices is they really didn't want to have a breach because of the public nature of it and the media pickup. So it was a really strong tool to prevent and increase your security. But when you did have to do a breach, you had to do a breach letter. And I do think they should have more disclosures about what happened, honestly, so everyone can understand and benefit from that. My question relates to actually the keynote. When you mentioned this morning when you thought that some of the reporting went down in the summertime, and you mentioned Ukraine and some other causes, what makes you think that those things impacted the number of notifications?
It clearly had both parts had an impact because the primary groups who have been committing a lot of the mass level um, uh, exfiltrations of data, either ransomware or even some of the very sophisticated now automated phishing attacks, all of a sudden they got called to duty to attack Ukraine as opposed to monetizing the theft of data. So you had some of the groups shift their focus. Or maybe they weren't called to duty, but they didn't want to draw attention at a time when the rest of the world was focusing on and looking for an increase in cyber attacks. They didn't want to be the reason everybody went, oh, it's them, and draw all the attention. So we did see that reduction in activity. Also, they make money primarily, those groups that are financially oriented, through cryptocurrency. Well, when the cryptocurrency markets went crazy, um, there was no money to be made. When you've got the exchanges filing bankruptcy right and left, and the value of the coins going way down or down to zero or less in some cases, that was no longer as attractive to them. So they, like every other business, has to retool. So they they did a stand down, they retooled, and they came back in the second half of the year. And that's where we really saw the supply chain attacks resume. They had been going down because it was much easier to get more money with a single ransomware attack than to try to go and steal data and then monetize the data you're getting from anywhere from 50 to 100 or several hundred organizations. That still takes time to monetize. But it was easier to get money that way than to rely on cryptocurrency or to go back to mass ransomware attacks, because then you think you're going to bring down the full force of the entire Western Alliance. So that's the general, and there are people in this room who probably know far more about it than I do. But that's the general consensus.
James, I would just add that we see similar trends from not just a breach perspective, but a fraud attack perspective. And during the pandemic, for example, a number of banks reported a decrease in the volume of fraud attacks during a certain period. And part of the reason is attributed to the fact that a lot of these large organized criminal enterprises, including some nation state funded organizations, were distracted with stealing money from the PPP SBA program and unemployment insurance. And because it was so easy to steal funds from those programs, they were spending all of their energy just ringing that cash register every day. And so they were leaving their other victims alone for a little while. And so some organizations were very excited. The banks were saying, "Hey, our fraud protections are working, and we're doing a great job, and attacks are down." And that wasn't necessarily the reason why. And of course, most of those institutions have now seen those attacks come back in force and are even worse. But they get busy doing other things, and when there's a lucrative target out there or something that needs to capture their attention, and these are large enough organizations where it can actually swing the global nature of fraud attacks. We do see that happen.
They are a crafty lot.
And I would note, despite the title of the panel, I think really the question is, do data security breach notifications work to protect consumers? I mean, that's mainly what I was answering. And, I think to a certain extent they serve a purpose, but a larger purpose, as you suggest, is that they spurred increased cybersecurity budgets. Also that it was a formal mechanism that now ties into cyber risk insurance. And those cyber risk insurers are really driving a lot of standard setting and requirements for information security.
I think we have time for one last quick question, if somebody has one. Otherwise, I realize we're standing between you and the restroom. So, or more of the bacon, egg, and cheese biscuits, or croissants, whatever they were. All right. Thank you so much. Obviously, we're going to be here for a little while. If you have other questions during the break, we'll be happy to talk to you. Appreciate it, your time and your attention, and go Nats.